Paragraph 19 of the contract deals with damage or loss, and basically damage or loss remains with the seller through recordation. So if we settle on a Thursday, typically it's recorded the next business day. So that as a seller, you don't want to cancel your policy until after you have your money in your hand. You cancel it, you tell them you settled on a Thursday, they'll backdate it till Thursday and everything's fine. But that paragraph means that should we have a hailstorm, which actually happened on the last settlement day of the month when you had plenty of settlements, and it tore up the house, that seller needs to have their policy in effect, even though the buyer is also going to be required to have their policy in effect as of the date of settlement. That would be an argument between insurance companies. The risk of damage or loss to anything of that nature remains with the seller through recordation. It's an important distinction. Title. Title is a big thing. You have the attorneys acknowledging in the contract that the title report and survey will be ordered promptly, and if not available on the settlement date, settlement can be delayed for up to 10 business days to obtain the report and survey, after which, at the option of the seller, it can be declared void, and any deposit would be refunded to the buyer. They're conveying fee simple title to the property, and it's going to be sold free and clear of any liens and or encumbrances. It will include the full bundle of rights. Important distinction in the third paragraph where it talks about seller will convey the title with good and marketable title, insurable by a licensed title agency with no additional risk premium. Sometimes there's a cloud on the title and they pass that on. It's up to the buyer if they want to accept that. That's what the seller's obligated to convey. If there's any action that's required to clear the title, that will be undertaken immediately, and that will be undertaken at the seller's expense. If the title is not good and marketable and insurable by a licensed title company with no additional risk premium, buyer, at the buyer's option, may declare the contract void or pursue all available legal and equitable remedies. Nothing shall be in this contract prohibits it from the possibility of being extended. Seller will convey the property by general warranty deed. General warranty deed warrants the title all the way back, back to the very beginning. Sometimes you will have a relocation company or such that want to convey it by special warranty deed, meaning they're only going to convey it based on what they warranted. Title insurance can protect you in that situation. The way that a buyer can take title, there's 3 different ways, depends on your situation. Certainly the attorney can give you some advice on that, and we can give you advice on that, but it's something that you want to, don't just take it lightly in that regard. You're authorizing in this paragraph for the settlement agent to obtain a payoff and other information regarding the existing lenders, and it's important to note that the seller will pay any special assessments and will comply with all orders and notices of violations with the county or local condominium unit association, homeowners, or property owners association. So if any of those associations have notices of violation that attach to the HOA docs, which we looked at early, it's not negotiable. Seller has to take care of it. If the association wants a tree cut down, seller has to take the tree down. If not, then that passes on to the buyer. But contractually, the seller's obligated to have that taken down in that particular case. Last sentence also protects the broker, and it releases us from any problems if there's a cloud to the title in any way, shape, or form. Paragraph 21, possible filing of mechanics liens. Mechanics liens can be filed up to 90 days after the date the work's performed. So in theory, if we're settling at 2 in the afternoon and that seller had work done that day, up to 90 days later, a lien can be placed against that property. At settlement, the seller is going to have to indemnify that he hasn't had any work done that he didn't pay for, but that's a protection in there, and that's something that the buyer is acknowledging and the seller is disclosing. Possession date. At settlement, they will deliver keys, key fobs, codes, digital keys, if any. The time to find out if there's any of those things is certainly at home inspection, but otherwise all the seller's obligated to give are the keys that they have in their possession, And oftentimes they don't have them for back doors or garage doors or that type of thing. But that's something that they're obligated to do. The seller is also obligated to get out of the house. If they don't get out of the house, they become a tenant at sufferance, and that's explained in this paragraph here. The buyer will then have the right to proceed with any legal means available to obtain possession of the property, and the seller would pay any damages or costs incurred by the buyer if they had to get them out of the property. 35 years, I've had that happen one time, and they were out. It just was a mover-related issue, and we wound up in court. But fees, spelled out in paragraph 23, basically this sets forth the closing cost. It tells the seller what fees they have to pay and what fees the buyer has to pay. Seller basically is paying to convey the property. The buyer is paying the cost to obtain the property. Most of those are loan fees. It does spell out in here that the congestion relief fee and the grantor's tax are paid by the seller. So sometimes if you have a seller that's bought a new home, they find out that the new home, the buyer pays the grantor's tax. But on resale, it's the seller that pays the grantor's tax. Paragraph 24, that is simply the language where the seller is instructing the settlement agent to pay the broker's commission as already set forth in the listing agreement. Paragraph 25, adjustments. That used to be called prorations. That is the paragraph where anything that has been paid for in advance by the buyer, everything is paid to the day of settlement, with the day of settlement being the buyer's day. Primarily what's going to be prorated are going to be taxes, condominium fees, HOA fees. If there's a tenant in the property, it might be rents, but that's all adjusted. And it also states forth that everything is going to be rounded to the most recent tax bill. That's what they will use to determine the taxes. So if taxes change in the meantime, they'll use the most recent bill. Attorney's fees. If either party has to sue the other party, loser pays the attorney's fees. That's how I typically explain that paragraph. But what this says, and basically this is the legalese that says that, damages are recoverable against any breaching party, so that if somebody breaches the terms of the contract and the other side takes them to court and prevails in court, then the other side is going to be liable to pay for the legal fees and that associated with having to collect that money. Brokers specifically indemnified from damages in the suit between buyer and seller. Performance. Delivery of the required funds and executed document to the settlement agent will be sufficient tender of performance. Meaning that as long as the buyer has brought their money and everybody signed all the documents, then we've met the terms of the contract, and the attorney is authorized to go ahead and pay off existing liens and encumbrances and disperse all the funds and have the title recorded. Default. Big paragraph. Both buyer and seller can be in default. The purposes of this will deal with buyer default. If the buyer defaults, their deposit is not automatically forfeited to the seller. Their deposit, it has to be mutually agreed upon as to its disposition. If the seller agrees to accept the buyer's deposit as solution for being in default, then they will take that, and there's no further penalty to the buyer. That is the limit of the damages that can be done. If, however, they elect not to take the earnest money as deposit, then they can come back and they can sue for further damages. Those damages might be additional hotel costs, lost deposits, carrying charges for mowing and utilities and HOA dues, etc. I mean, the damages can be quite substantial. In the event, and it says in paragraph 3, broker may accept, it's always our policy to not, and the seller agrees to pay on this broker 1/2 of the deposit in lieu of the broker's fee as provided by the share of any forfeited deposit. So what that means is that if the buyer goes into default and the seller, and the buyer signs over that deposit, according to this, at our option, we can collect that. We can collect half of that to offset our not getting any kind of commission and doing all that work. That being said, not something I've ever done, not something I intend to do, but that's what that language says. It's not just the buyer that can go in default. The seller could go in default. I've had the seller go in default on at least 2 occasions. You know, the seller can go in default. Again, we can't make them sell their house, but they can be sued for damages. There's no deposit to sign over, so it would actually take an attorney to pursue litigation, and then there could be damages that are held. If either the buyer or the seller is in default, then in addition to the other damages, and this is the last paragraph, the defaulting party will immediately pay the cost incurred for title exam, appraisal, survey, and the broker's fee in full. Strong language. That's in the back there. Hopefully we never have to go through that. Other disclosure, paragraph 29. These are disclosures that are there. Basically, a lot of them protect us in the course of it, but they're there to make sure that the buyer and the seller are aware of the different things that are offered to them. The broker can counsel on real estate matters, but if legal advice is desired by either party, such party is advised to seek legal counsel. If appropriate professional advice concerning condition of the property or tax or insurance, you need to talk to specialists in that industry. We can counsel on real estate matters. That's the gist of that first paragraph. In addition, we're not advising the people. It's paragraph A. We're not advising them on the existence of FRT plywood or synthetic stucco or any of that kind of stuff. They're all detailed in that paragraph to include planned land use in that. That's something that we're held harmless for, and that's what that paragraph does. But it also does it by making them aware that they have the right to check any of those things. It's in writing. When explaining the contract, we point that out. Those are things that we're not allowed to discuss, we're not held liable for, but they have the right to seek outside advice on that. To seek outside advice on any of those things, from FRT plywood or stucco, that type of thing, they have to disclose it in the contract. The alternative to that is if the home inspector actually does an inspection for those type of things and includes it as part of the home inspection report. But it needs to be in the contract unless it's handled at home inspection, specific thing. Legal requirements. To be enforceable, things need to be in writing. Oftentimes in the course of a transaction, furniture is negotiated, occupancy can be negotiated, and the buyer may turn around and say, oh, don't worry, if that stuff's not out of the house on moving day, that's fine. We're not moving in for 3 days. Well, something like that comes up, it needs to be in writing. Put it in writing so that it's there and is memorialized. Otherwise, it's not enforceable. Had a property one time where we go to walk through and there's a pool table left in the basement. And I'm representing the seller. I called the seller, and the lady's most upset by it, the wife, the buyer, and most upset. And I called the seller, and he's getting on a plane. He says, look, he said, I talked with him, and he said, go ahead and leave it. He liked it, And everybody looks at Mr., and he's kind of sheepishly, he had said that. At the end of the day, had to be out of there. I had to get a mover over there basically at my expense. Of course, now that pool table's in my basement. But nonetheless, that's the type of thing. It needs to be in writing. We've had all kinds of issues with that, from people that were going to leave a dog. The dog was going to convey, and the buyers show up with collars, and bowls with the dog's name, and the seller said, oh, my daughter took that dog, and was just nonchalant and didn't think anything of it, and the buyers were devastated. Things like that need put in writing. Had we been aware of that, we would have made sure that was in writing, but that was just an agreement where somehow the buyers and sellers started talking, and that came out. Financing. we don't set the rates. We don't know what the rates are. They're charged by the lender. What one lender charges, another lender may be higher, another lender may be lower. They're associated with the financial institutions, and their rates are set by market rate, not by us. The broker, in this case, that would be us, certainly representing our client. But we're retained solely as a real estate agent, not as a tax advisor, a lender, a surveyor, a structural engineer. Any of those kind of things are beyond the scope of what we're hired for. So while we may talk about that, we always need to say, talk to your accountant, but here's my position. You need to talk to a structural engineer, but this is my opinion. You always have to caveat that, but that's what this paragraph is it's in writing. What this is saying is that we could get fees from other things associated with this transaction. That being said, not something that we do. We refer our handyman over there. Handyman's not giving us any money. We have JD paint the house. JD's not giving us any money. But this paragraph says, that the broker, and the broker in this case is Long & Foster, if we use their title company, they're probably making some money on that. If we use their concierge service, there's probably some sort of income in that. But there's nothing that we specifically do or take. Property taxes in subparagraph E, we're representing that the tax bill could change following settlement. Kind of falls under duh. It does, taxes go up. But we're representing what it is as of the date that the contract is written. What the most recent records are, that's what we're representing. Property insurance. Obtaining insurance is typically a requirement of the lender to secure financing. Insurance and availability are determined in part by the number and nature of claims made on the property's policy. We can advise the buyer to call and get a quote, which is what I would do. If you're trying to figure out the actual cost, the lender's going to use hypotheticals. But if you have a property address, you can call down. You can call down and get a clue report to find out, it may cost $15, but if you're going to be buying a property, that might be a good idea. It'll let you know, are there any specific claims that have been filed against that property? And property insurance is sometimes difficult to get. So they need to get hopping on that. There's no guarantee, there's no contingency upon them, being able to obtain insurance. So they should consult an insurance professional quickly. Title insurance. Title insurance, I'm a believer in. I don't know that I'm a believer in getting the enhanced policy, but I'm a believer in title insurance. I have it on every property that I have, and it's not inexpensive, but it's peace of mind. And it's used very rarely, but boy, when it's used, you're glad that it's there. And with title insurance, they're going to offer you a standard. They're going to offer you an enhanced policy. I'm not going to go into detail on that, but that's something that just, when you sit through settlement, you'll hear them go through the spiel on that. Enhanced policy is just that. It has a little higher degree of protection for the buyer. But the fact is, I see that used less than 1%, probably less than 0.5% of the time. But as I said, the times that people have had it, it's been needed. Nothing obligates the buyer to obtain the owner's title policy. That is something, and that's an important distinction in the contract. They're not obligated to get the owner's policy. The lender's going to require them to protect them with a lender's policy, but it's the owner's policy that they're not. By default, at settlement, when you're at default, the title company's going to offer up the enhanced policy. You can always say, we want the regular policy, and shrink it down. It's worth ahead of time calling down and getting the information on it so that you can explain to the buyers what the differences in the policy are. It can make settlement brutally long if they have to go through that as settlement. And it's something that it is optional, so it's something that is worth taking care of ahead of time. Paragraph 30, assignability. This contract may not be assigned without written consent of the buyer and the seller. Assigned means you can't say, I'm not going to buy the property, but my Uncle Joe is. That's assigning the contract to them. Relocation companies routinely have the seller assign the contract to them. That's probably the only time you're going to run into that, but this basically said it can't be assigned unless both buyer and seller agree in writing, and it's important to note that if for some reason settlement does not occur, the original parties still are obligated on their part. Definitions, can go through that pretty quick. Date of ratification, that's the date of after the final acceptance in writing by the buyer and seller of all terms. It's noted on that last line before the signatures in the contract. That's where the date of ratification. The date of ratification is after all parties have agreed and signed and initialed the contract. There's nothing left to sign. It's done, it's ratified. Appraisal is a written valuation of the property. That's an appraisal that is done by a third party. It's done by the lender. That's who's in control of it. Days mean calendar days. Singular means the plural. Any references to the time of day shall refer to Eastern Standard Time. So when it says 9 p.m., it's 9 p.m. Eastern Standard Time, not Pacific Coast Time or anything of that nature. For the purposes of computing time periods, the first day will be the day following delivery, and the time period will end at 9 p.m. on the day specified. So if a contract is written on Sunday night and it's ratified on Sunday at 8 p.m., the time doesn't start until 12:01 Monday morning. That's the start of the first day. When it says end of the day, 9 p.m. constitutes the end of the day. If they're trying to deliver us some addendum, they can't delay it until midnight and say, oh yes, we got it in under the wire. It's not. It's due 9 p.m. is close of business. When it refers to the masculine in the contract, it's also referring to the feminine. When it talks about something in the singular sense, it also means the plural sense. That's just technicalities in the writing, so they can't say, well, it doesn't say she on there. It does. It says it means both of you. Legal expenses. Legal expenses are spelled out, and they mean attorney's fees, court costs, litigation expenses, if any, including but not limited to expert witness fees and court reporter fees. So that's all that's clearing up what legal expenses are when it's referenced in the contract. Notices. Notice is an important thing. That is a unilateral means of communication from one party to another. All notices need to be in writing and delivered according to the delivery paragraph that spells out delivery. The only time a notice will be given, we may give them notice that we're not going to move forward on the contract because of the home inspection. We don't have to give them a reason, we just give them notice. After that, the contract's dead. If there's none of this, well, I'm not signing that, you don't have to sign it. It just, if the buyer gives notice to the seller or the seller gives notice to the buyer, contract is dead. In some instances where the seller will give notice to the buyer is given 72 hours to remedy that, i.e. on if the financing contingency has expired or the appraisal contingency has expired, those type of things. The term buyer and purchaser can be used interchangeably in this contract. Seller subsidy. I went over this earlier when we were on the first page with seller subsidy, but what this says, it's a payment from the seller towards the buyer's charges, including but not limited to loan origination fees, discount points, buy down, subsidy fees, prepaid or other charges. The important part to notice is the last line, which says it is the buyer's responsibility to confirm with the lender that the entire credit provided herein may be utilized. If lender prohibits seller from the payment of any portion of this credit, then said credit shall be reduced to the amount allowed by the lender. So if we blindly go in and say, let's ask for $10,000 in closing, and there's only $8,500 worth in closing, we just lost $1,500 for the buyer. The seller comes out $1,500 ahead. So in asking for closing cost assistance, make sure that we're asking specifically for what we can get and no more, because we're not going to be able to get what we ask for more. It doesn't just get reduced off of the sales price or anything of that nature. So that's an important thing there. Paragraph 32, miscellaneous. The contract can be signed. There's a place to initial each page, but the contract can be signed on the back page. That's where it's signed. It also says documents that are obtained via facsimile or a fax machine can be counted as, will be considered original. And the important line on that is typewritten or handwritten provisions included in this contract will control all pre-printed provisions that are in this contract. So if there's something that's pre-printed in the contract and then there's verbiage that is handwritten into that contract or typewritten into that contract and initialed and all parties agree to, it will override what is pre-printed if there's a conflict. That's an important distinction in the event that there's a dispute and somebody's hanging their hat on something that's written into the contract, but there's something else written that overrides that. That's where that language is. Paragraph 33, void contract. This simply states that if this contract becomes void, not default, but if the contract's voided on the home inspection, voided on the HOA docs, voided on the appraisal, voided on loan commitment, any number of ways for that to be voided. If the contract goes void, then immediately the other side has to send in notice and fill out a release so that the earnest money can be released back to the borrower. If they're in default, they don't have to do that. It's only if a contract is legitimately voided. Paragraph 33, home warranty. The home warranty, I hate them. Thing of the past. I think they're a waste, maybe a profit center for the companies, but I typically counter them out, and I don't like to ask for them because I think if you can get them to pay for an expensive warranty, you can get more off the price in negotiation. But that paragraph just says, all that does is say, yes, there's a warranty, or no, there's not. And if there is, who's paying for it, whether it's the buyer or the seller. And if they are paying for it, how much is the maximum amount that the seller is going to pay for? If you go in and ask for $750 worth of warranty and the highest warranty is $500, then there's $250 you're not getting. Time is of the essence. Paragraph 35. Huge paragraph, in my opinion, in the contract. Time is of the essence means that the dates and time frames agreed on by the parties must be met. That's the exact language from the contract. Failure to meet the stated dates or timeframes will result in a waiver of contractual rights and will be a default under the term of the contract. The exemption to that, though, is further when it says if this contract is contingent upon financing and the contingency has been removed or satisfied, then any delay of the settlement necessary to comply with the buyer's lender is not a default by the buyer. But it does give the seller the option to declare the contract void in writing. So you don't meet it, you don't get to go on in perpetuity, but you're not going to be in default by that either. The seller can declare that void. Nothing prevents the parties from mutually extending it, but they're not required to. Arbitration, paragraph 35. Nothing in the contract requires arbitration. Nothing precludes arbitration from being a means to settle any kind of dispute. If there's an arbitrator that both sides are willing to abide by and both sides are willing to fund, then it's doable. But nothing shall preclude arbitration as a means to settle that dispute. Paragraph 37. Real estate license parties, this is just where a buyer and a seller are acknowledging that they don't hold an active or an inactive real estate license in Virginia. It's also where if the other agent is related or if you're related to the buyer, this is where you disclose that. It's important to notice if you're helping your sister or your mother or somebody buy a home, then you must disclose that you're related to that party. If you're helping somebody buy a home and they hold a real estate license, then we need to disclose that in paragraph 37. Paragraph 38. I always say that this is the legalese that makes this a binding agreement, and that's exactly what it does. This contract will be binding upon the parties in each of their respective heirs, executors, administrators, successors, and permitted assigns. Just read that verbatim off there. It says, this contract, unless amended in writing, contains the final agreement of the parties, and the parties will not be bound by terms, conditions, oral statements, warranties not represented herein. So this becomes the final document, and anything that's not in here is not binding. But it's the legalese that does make this a binding agreement. It goes further to say that the interpretation of this contract will be governed by the laws of the Commonwealth of Virginia. Paragraph 39, additions. The 13 pages that I've gone through thus far are the main body of the contract. They're the main body, that's the core of the contract. However, there is specific situations that are addressed by addenda. What this is stating is that, like for instance, typically there's a home inspection. There's a home inspection, a radon testing contingency. Is it attached? Yes or no? So if you turn around and fill out a home inspection or radon testing form and you don't acknowledge down here that it's part of the contract, it might just disappear. It might, then all of a sudden we have a legal problem. So anytime you have that, you need to address it down here in the contract. It's pretty straightforward. Usually there's a home inspection or radon. If there's a special circumstance like a contingency on sale of the home or something of that nature, that would be in the contingency and clauses addendum. It's rare there's a pre-settlement. There's always a residential property disclosure, and that shows that it's attached. So we can download that or sign a blank one. FHA inspection notice, if it's an FHA loan, that will be attached. Conventional financing, if that's the type of financing we're using, that's always going to be attached. Home sale addendum, I've never used that. Extension review period for a condo resale certificate, I've never used that. If there's a well and a septic on the property, then there's a well and septic addendum. Post-settlement occupancy, use that with some frequency, a couple times every year anyhow, and that's filled out and that's attached. But everything gets a yes or a no. There's nothing, we don't just check the yeses and we don't just check the nos, we check them both. And any addendum, it needs to be noted here. If there's conflict, that's a problem. Paragraph 40, a great paragraph. Listing broker and selling broker are hereby authorized to release the sales price listed in the price and financing paragraph to any appraiser who contacts them to obtain the information. It's a great thing. Back in the day, we weren't allowed to do that, and the appraiser would come out to try and appraise the property, and they had no idea. They had no idea what number they were shooting for. I mean, appraising something at 200 or 205, you can usually work that out. But if they didn't know they had to get to 205, they're liable to come in at 200. It's a blessing to be able to do that. But we're allowed to disclose that price to the lender. We're not allowed, and an important distinction is we don't go out and talk about any of our sales prices until after that property is sold and that property is noted in the county records that the sale is complete. Paragraph 41, other terms. If there's language that we need to write into a contract, this is the place that we write that into the contract. We don't write it arbitrarily, and agents do that, and I think they're trying to sneak it by, but any other terms that we need to write in, this is where we typically write them in paragraph 41. So paragraph 41 is basically the last page of the contract, although right behind that in page 13 at the top of that it'll have the date of ratification, then it'll have the signature blocks, then it has a dotted line. That dotted line, anything that's below that line can be changed. We don't have to get it initialed. That's the cooperating broker's address, that's the listing broker's address, that's, in terms, that's where that goes. Anything above the line that is changed has to be initialed. So that page is where the date of ratification goes. The date of ratification goes once everything is signed. Once the last initial is in, then we put the date of ratification. That's where you find it in the contract. That should be handled, again, not until everything is in. Don't fill it in and then send it back for an initial. Whoever's putting the last initial on, they're the ones that have to put that date of ratification in. That's it.